Hi everyone, I'm Nick Gill from the University of Exeter. Thanks very much for the invitation to join you today in the Socio-Legal Studies Department at Oxford. Thanks to Linda and Lena for the invite. I'm sorry I can't be with you in person. It sounds like a great series of seminars that you've got going, and that you get to go out afterwards and have that social time as well would have been fantastic. But we do what we can during lockdown. So what I've done today is recorded a presentation. I'm recording the presentation that I would have given. I hope you don't mind. I'm recording it in advance. Just it's easier for me with my personal situation. Sometimes I get disturbed by the children. So I'm recording it in advance, then we won't be disturbed. But I'll be around for the question and answer at the end live. And also my researcher, Nicole, will be around as well. So before I get started, just on that theme of researchers, just a big shout out to the researchers that I've worked with over the last few years, studying asylum appeals in Europe, which is what we're going to talk about today. There's quite a long list of them, so I won't name them all, but my lead researcher at the moment, Nicole, is going to be with us for the Q&A, as I mentioned. Right, I'm just going to get the PowerPoint started. Okay, so hopefully you can see all that. Slight change of title, as always. I think that's compulsory, isn't it? Okay, so our research at the University of Exeter is under the project title of ASYFAIR, and it's the European Research Council funded project that looks at asylum appeal processes in Europe. And it began 2016. It's got about another year to run. We've had an extension because of the COVID. It's got about another year, so we're probably about 80% of the way through it. And it's involved us observing quite a number of asylum appeals, over 850 asylum appeals, if you include some preliminary work before ASYFAIR as well. And it came at exactly the time when asylum appeals were becoming really busy in Europe. The courts that were specialising in asylum around Europe saw an increase in numbers, and we saw shifts, large shifts of judicial expertise into the area of asylum as well, and away from other areas of law because of the so-called migrant crisis or refugee crisis 2016 and 17. And for example, in 2017, there were over 300,000 asylum appeals determined in Europe. And of those, just out of interest, about 30% delivered some form of positive decision, either an overturn of a negative decision or an improvement on the situation, the decision from before. And so that indicates, firstly, that about 1 in 3 government decisions that are appealed are found to be erroneous at the appeal stage in Europe. And it also reveals, I suppose, consequentially, the importance of the appeal in Europe, the importance of these processes. So that's what we're talking about today. And as you can see, that it's enshrined in law, this effective remedy, and you'll be very familiar with this in the legal studies world. Remember, I'm coming at this from a geographical perspective, so I'm a bit of a kind of explorer in this area, but you may well be familiar with the international law in this area. The Universal Declaration of Human Rights, for example, and then more geographically situated, geographically specific international law as well, such as the Common European Asylum Policy, which also stipulates this effective remedy that should be available to everyone if they're refused asylum. And the United Nations High Commission for Refugees talks about the importance of the following features for asylum appeal processes to be effective. First of all, they need to be independent. Secondly, they need to afford the appellant, and I will use that word appellant from now on, prompt access to interpreters, information about the legal process and legal advice. Thirdly, appeals should be practically accessible, and I guess we're going to talk quite a bit more about that today. What we're interested in, though, is not the doctrinal or the written aspects of legal processes, but what happens in reality. How are these legal processes experienced and managed on the ground? There are various actors involved in asylum appeal processes, and what I'll be talking about today, because we've observed a lot of these, are asylum appeal hearings. Now, not all asylum appeals are determined via hearings. Many of them are determined on paper. In fact, an increasing number are determined on paper, but we've been able to observe the hearings, and I think by observing the hearings you get to see quite a lot about how the law operates. You know, there's a huge tradition of legal ethnography and court observations in socio-legal studies, and increasingly in geography as well, I'm pleased to say. So there are various actors involved in these hearings: the judge, the appellant, the lawyers, The idea is to give the refused case, a reconsideration, but there are multiple differences of race, ethnicity, religion, language, nationality that can present obstacles to effective access to justice through these means. Applicants can be carrying the consequences of trauma as they go into the hearings as a result of happenings in their home country, their origin country, I should say, also on transit, en route, and also, unfortunately, in their destination countries via things like immigration detention. There are language barriers that come into play. There are difficulties of disclosure. There are often difficulties of interpretation, finding the right legal expertise. And there's quite a literature on this already. There's often difficulties around legal advice as well, including exploitation by lawyers. So this is a really difficult, sensitive, but hugely important area of law that we've been looking at over the last few years. So the ASYFAIR project involves over 850 asylum appeal observations from the public area of the hearing rooms where these hearings are held. Also around 150 interviews with various actors, judges included, but also appellants themselves, which we really wanted to do, and legal professionals. And what we're interested in conceptually is how fragile legal protection for asylum seekers in Europe is in reality on the ground. Fragility refers to the quality of being easily broken or damaged. In a legal context, we take this to mean the ease by which systems and laws that are put in place to protect refugees become or are made dysfunctional, impractical, and unrealistic in concrete settings. Our work offers a partial, situated view of the encounters between legal subjects and legal systems, and it's not intended to be universal or holistic, but it does emphasise the experience of migrants, the materiality of law, and the wide cast of actors involved in bringing asylum law about. And the research question, what makes the system of protection of asylum seekers via appeals in Europe susceptible to failure or ineffectiveness? And what I'd like to touch on today are 4 points in particular. First of all, I want to reflect on the questioning tactics of judges and ask what those questions reveal about judging and the assumptions that judges make. Secondly, I'd like to spend a bit of time talking about the atmosphere of hearings, and really what I'm doing there is following the interviewees themselves, the appellants, because they will often talk about particular types of atmosphere that they encountered. Was it cold? Was it warm or welcoming? So we'll talk a little bit about atmosphere. Thirdly, I'd like to talk about quantitative pressure and the speed with which hearings are conducted, because we saw hearings and hearing systems when they were under quite a lot of pressure, so we're able to talk about that. And fourthly, I'd like to talk about the incompleteness of hearings. We found it very productive to ask what's missing from hearings as well as what's present, so we'll talk about that as well, drawing on some geographical theory around absence and presence. So first of all then, what do judges reveal about the way that they're thinking about asylum cases through their questioning? Because of course we weren't able to look inside judges' minds, but we are able to hear their types of questions. And I'm going to kind of dive in really into some real life situations that we saw. So just by way of a caveat, we saw quite a few judges that were really fantastic in terms of their questioning. And I don't want to give the impression that judges are all kind of problematic at all. But it's just that some of the things that I'm going to share with you really caught our eye. So to dwell just for a moment on some of the good practices that we saw with judges, and Nicole might want to come in with a few more here. And I've certainly got a long list that I can go through during the presentation as well. One of the things we really appreciated was when judges explained why they were asking what they were asking, as well as asking the question itself. So it seemed to really help the appellants, put them at ease. And we found this, we kind of discovered this through both their interviews and through their observations of them. It put them at ease when they could understand a little bit more about why judges were asking the sorts of questions they were asking. Remember that when judges are asking questions of appellants in these hearings, they can be intensely personal. So it can be about sexuality, it can be about gender, religion, extreme violence. So it's a very sensitive area for questioning, and it requires an awful lot of very careful judgecraft and skill. And most of the judges that we saw, I think it's fair to say, it was clear that they had given a lot of thought to their approach. But I'm going to just share with you some examples of things that we were a little more critical about. So this is from a conversion hearing in Austria, and I hope that this will be just the start of an opportunity to discuss some of the conversion hearings. I know Leonard's working on the conversion hearings as well. These are a list of questions that Nicole noted down during quite a long hearing, and in general the conversion hearings tended to be very, very long in comparison to the other ones. And I just want to give you a sense of the types of questions. These were coming at about every 30 seconds to a minute in frequency. What's the difference between Islam and Christianity? And then the applicant would respond. Typically, they would fail to respond in a particularly cogent manner, because the atmosphere in this hearing was not a great atmosphere. We'll talk about atmospheres in a second. I'll carry on. What's the difference between Islam and Christianity? Are there any similarities between Christianity and Islam? Any at all? Tell me, what is the position of women in your religion now? And what is the position of women in Islam? Tell me again, when was the exact time you converted to Christianity? The exact time. Do you know the meaning of baptism? Let's come to Christian principles of faith or dogma. Do you know them? What is the Holy Trinity? What is it composed of? Why is the cross the symbol of Christianity? What is its meaning? Tell me, what is the meaning of life? Are you personally afraid of death? What do Christians believe about death? Is there life after death in Christianity? What is the meaning of heaven and hell? You said you will be in paradise with Jesus after death. How do you imagine that? I ask again, how do you imagine paradise? Annoyed now, so that's Nicole's notes. No, how? What is it like? End quote. So just to reflect a little bit on that, and it's compressed, that type of questioning. It was over probably about half an hour in total. But I just want to draw out a few points about the assumptions that judges might be making, some judges, about how to judge a genuine Christian conversion. So it appears as though genuine Christianity entails a detailed knowledge, a very detailed knowledge of the Christian faith, which in itself can be quite controversial. It also appears as though conversion, the moment of conversion, is indeed that. It is a moment. It's not a gradual thing. And there's quite a lot of literature that would contest that. It also assumes that there's a right answer. So with a lot of these questions, they're theologically quite sophisticated questions, and they could be debated. And what's more, various different strands or denominations of Christianity might well have very different responses to the questions that have been posed. And finally, I think it assumes a degree of adherence that we wouldn't necessarily expect from Christians in Europe. And there might be good reasons for that, because I guess you'd need to have a certain intensity of faith in order to want to migrate and choose migration rather than to try to hide your faith. But at the same time, it's not comparable in terms of intensity to what we'd expect in a European context a lot of the time. I think that's fair to say. So I think what would be really fascinating as a follow-on study around these sorts of issues is to ask Christians or people of faith, because obviously there are questions around other faiths as well in asylum appeal contexts, who aren't claiming asylum, what the answers to some of these questions are, and to make a comparison. Unfortunately, we didn't do that, but I do think it's a really interesting way to start to discuss the kinds of assumptions that are made via judicial questioning. And as I say, it's not intended to be an exhaustive argument. What I'd like to do is just open up the floor to some discussion and some questions through that anecdote. There are various other types of questioning habits that I think reveal something about the judges that we observed. So sometimes we found judges using their own experience quite frequently. So again, in the context of Christianity, they would talk about their own experience of particular Christian faith and use that as a yardstick for assessing claims of credibility for conversion to Christianity, which we found interesting and potentially quite problematic. At other times, we noticed self-revelatory judicial practices. So that is, but what we mean by that is that the judges would occasionally reveal what they thought about a case early in the questioning. I'll give you an extreme example of this. Again, it's meant to be a discussion starter, really. So this is from ethnographic notes. Right at the start of the hearing, the judge goes straight to reprimand the appellant. I am irritated because you lied several times. You can grin, but I don't find it funny. So this is opening lines to this appellant. And then the notes, the appellant is smiling, but I think that's just his way of looking. The lawyer sighs and leans back as if he already knows what's going to happen. We continue with the judge. Firstly, we have several dates of birth here, and a lot of your story does not add up. You know that you cannot be deported without a passport, and I'm obliged to have an hour-long hearing now, but nothing justifies the lies. I'm aware that young asylum seekers can be treated badly and that it may not be easy. But here he sits, and now he's talking as an aside to the lawyer, grinning, and I should record it because I find it very irritating. In 15 years as a judge, I'm not interested in investigating lies. Credibility is about whether you can be believed as a person, and I tell you honestly, I do not believe you at all. So we didn't see the notes for this hearing. We didn't see what the judge had seen. But at the same time, it's, I think, fair to question what a hearing like that, what the purpose of a hearing like that, when the judge starts the conversation in that manner, because it's fairly reasonable to assume that the ability of that appellant, who was 16, was 16 at the time of the event, but was still a young appellant, the ability of that appellant to respond in an even-handed way and an informative way when they know that the judge is being cynical. There needs to be a level of engagement between the appellant and the legal process that needs to be carefully nurtured. And if the appellant has reason to suspect that what they say is going to be cynically disbelieved from the outset, it may very well undermine their stomach for engaging in the hearing. So that was one of the other concerns that we had. So in general, what would we say about judicial questioning? It's susceptible to mood. It's susceptible to previous cases. It's susceptible to the personality of judges, the emotions of judges and others in the courtroom, and also to assumptions, some of which are culturally inflected and culturally informed. So I think it's a fascinating area to look at, the questioning of judges, and something that we looked at quite a lot in our empirics. And I'll point you perhaps to some of the publications and papers that mention some of these questioning issues towards the end of the talk. I've got a list of publications that are coming out of the project. Next, I'd like to talk about atmosphere. One of the reasons I'd like to talk about atmosphere, aside from the fact that geographers have spent a probably unhealthy amount of time theorising atmosphere in recent years, is that actually appellants in their interviews often refer to particular types of atmospheres in association with the hearings. Sometimes they've described them as cold, and in fact that was probably the most common, cold or calculative hearings. They're not feeling it's a bad situation. Sometimes it was just a bad atmosphere or a nasty atmosphere, and that came through quite a lot in the interviews that we did with the appellants. So we became interested in what causes an appellant to think in terms of atmospheres and what's the significance of thinking about atmosphere. And one of the things that we argue in a paper, again I'll list it at the end, that's concerned with atmosphere in hearings, is that it's very much not just the usual suspects and the central actors that have very, very important roles in the hearings, that, as we would see it, that generate these atmospheres. So the classically important actors are the judge, the lawyers, and probably the interpreter as well. Although the interpreter is kind of on the fringe in the sense there's a lot of literature on the extent to which an interpreter can and should influence a hearing. But what we're interested in this paper are the kind of fringe actors, the clerks, the security staff, and the others who are there, even the public and other appellants who are observing the hearing. Because they're the ones that often get overlooked when we're talking about legal processes, and for good reason. You know, the judge and the legal representatives for both sides, they're the ones that do the argumentation. But from the appellant's perspective, these peripheral actors or these kind of minor actors can have a disproportionate effect on their experience of the hearings. So the clerks, and we've found this as well as talking to the appellants, whether they smile or not, whether they're brisk in their manner, whether they have positive or warm body language or not, these things matter to the atmosphere of the hearing, and they can affect how trepidatious you feel going into the hearing, even as a researcher, never mind as an appellant. Some clerks can use their positions very positively. We've heard stories in the UK of clerks that would, as soon as a hearing was adjourned, occasionally rush out and get a new hearing date right then and there and agree it with the judge before everyone dispersed at the end of a hearing, saving the appellant weeks, potentially months actually, of waiting until the hearing had been rescheduled. So clerks can be very helpful. We've seen clerks rush into hearings on their own initiative with late evidence that has been very helpful for appellants. So I just So that's the first kind of category of actor that perhaps gets a little bit overlooked, but an ethnographic approach, when you spend so long in hearings and hanging out in hearings, you begin to realise how important those types of actors are. Another one, perhaps even more important, is security. Now, when it comes to asylum seekers and refugees, they can be extremely sensitive to security and security practices. They may well have experienced state-sanctioned violence or violence from people in uniform in the past. So, and the last time they came in contact with authority like that might have been in a very different and potentially awful situation. So they can be very sensitive to that. And the next thing to remember is that within the spatial layout of the courts, it's very often the security is the first thing that's encountered, the very first thing in the court. So it sets the atmosphere, it can set the tone for the entire hearing, depending on how the security guards treat the applicant. So this is the case we want to make in terms of atmosphere, is that these kind of peripheral actors can have a disproportionate effect on the abilities applicants have to engage with the hearings. And they varied greatly. So some security staff would be bordering on pedantic, so requiring all sorts of things to be emptied out, requiring people to go around again and again when it was clear that that the objects that they were carrying didn't pose any significant threat. But of course, that's a value judgment. But a clerk that we interviewed described the security staff in their particular centre as having the attitude that you are just like cattle. That's the quote. You're just like cattle. And an appellant describes it as, you feel like a criminal because you see the guard and then you talk to the judge and they don't believe what you are saying. This appellant, we found that was strategically, that was particularly significant because they'd made a direct connection between the treatment, the criminalising treatment at the hands of security staff and their approach to the judge. They made a connection between the two. On the other hand, we also found security staff who were really, really helpful, giving directions, building up appellants. We had one appellant that told us that they felt extremely confident going into their hearing because of a conversation with a security guard who'd said, you know, you can do this. We'd talked to security staff and they'd told us some of the things that they do, some of the ways that they look after the appellants. And there was one particular security guard who we observed playing with children during the hearings when the parent was in, usually the mother was in the hearing, making them feel at ease, making the security process at the start before they enter into the court into a game. So there are, it's impossible to generalise, and we shouldn't generalise about security staff, but what we want to do here in this section of our argument and our findings is to emphasise the influence that these kind of pseudo-peripheral characters can have over the approach of applicants to their hearings. We also noticed that other people in hearing centres can have an effect, especially if the hearing centre is busy. There can be shouting, there can be crying, arguments that we've overheard in the corridors, people on mobile phones interfering or interrupting hearings, children running around and playing. So some hearing centres in Europe represent the whole country. So the CNDA in France, that's the central asylum court for the whole country. Others are much more dispersed, so it's 50 or more. I think it's 50 in Germany. And it varies across different countries, how centralised these are. But in the busy ones, we noticed that appellants would often go ahead of time to watch other appellants' hearings. And it could make the appellants nervous to have a large audience, especially if they were talking about sensitive topics. And perhaps, I'm not going to have time to talk about it here, but maybe we can talk about publicness a little bit more in the Q&A as well, because there were some situations where we felt that the publicness was calibrated more for the public themselves than for the appellant. So just before moving on from atmosphere, I want to share a discussion of Ben's. Ben's talks about atmosphere a little bit, and maybe I can provide the reference if you're interested in following this up. Ben's emphasises that participants feel an atmosphere as an integrated whole, not only as a sum of individual components. So it's the sense that when we talk about these legal actors, the judge or the legal representative, we often talk about them individually and their individual behaviours, whereas participants often experience atmospheres as a whole. And actually talking about atmospheres allows us enables us to reflect that. Ben recommends attending to atmosphere because it has the potential to move beyond what he describes as the analytical logocentrism of speech and utterances in court proceedings. This is not, he stresses, an argument for abandoning the content of speech, which is clearly foundational, but a way to include linguistic and non-linguistic elements in approaching courtroom events. Central are the relational dynamics that unfold between co-present bodies in space and the overall atmospheric feel that emerges as a result of it. This may be comprised of material and infrastructural elements, visual and sonic aspects, and factors related to performance. These ingredients of courtrooms constitute a rich, underexplored world of affects that powerfully influence courtroom dynamics. The third of our four, the influence that actors can wield, I've already talked about. The third of our four kind of cuts into understanding these asylum appeals from a kind of socio-legal perspective, which is what we're doing today, concerns speed. Here are two photos taken from the strikes at the CNDA that we observed in 2018, at the time of our first set of fieldwork. We did some in 2018 and two sets of fieldwork, some in 2018, some in 2019. On the right, you can see that there's a protest. It's the strikers who've gone on strike to protest against the quantification and speeding up of the asylum process. There will be a lot of rapporteurs. We're going to talk about those. They're involved in the hearings in France, and legal representatives there on the right. And on the left, what you've got is a coffin containing, symbolically, asylum itself. So they turned the protest into a funeral for asylum, the death of asylum. And what they're protesting against is the acceleration of procedures in France that were introduced during the time of our fieldwork. They included decreasing time limits in order to claim asylum, increasing possibilities for ordinance, which means deciding on papers rather than in front of judges, and a reduced likelihood of putting the application in front of 3 judges, so panels instead of 1 judge. And in France, a variety of measures such as these have resulted in the workload at the CNDA increasing rapidly. So from 2007 to 2018, it more than doubled from 22,600 cases to 47,300 cases. And what they've had to do at the CNDA, because of the pressure of the numbers, is to introduce a 40-minute time stop for hearings. Hearings should in principle take 40 minutes. So there's a kind of big difference between some of these hearings that we saw and elite hearings at the kind of apex of the legal system in comparison to some of these lower level court processes that we saw, or tribunal processes. And it can mean that judges are sitting through 13 cases, a maximum of 13 cases a day. And our researchers, Jess, who I worked with, also sat through through some of the hot summers in Paris that you might remember. And she'll have stories about how difficult that was. Maybe we'll come back to that in the Q&A as well. But what I want to talk about now is some of the consequences of the measures that were taken in France to speed up the asylum process, the appeal process. So first of all, this could come straight out of Mariana Valverde's book on chronotopes of law. One of the things we noticed is that the spatial layout within the CNDA reflected the imperative of speed. 703 people passed through the CNDA roughly per day, and the court has become arranged as a kind of conveyor belt or a tube. So you come in through one entrance, but you actually exit through a different entrance. We thought that was quite significant in itself. And then movement through the various pieces of the court is compulsory, and it's quite heavily policed. You're not allowed to loiter in the corridors. There is actually one place in the CNDA, they do it digitally now, there was one place where they put up the results of the hearings. And when we first went to the CNDA, we thought, oh, we're going to get the hearing outcomes just by looking on the notice board. But what we found was we weren't allowed to stay for long enough to systematically look through all the hearings that we'd observed over the last few weeks to get the judgments, even though they were relatively succinct on the notice board. And that was because the security staff was so keen to keep people moving along and moving through the corridors. There were waiting areas where you could rest, but the corridors were seen as a space of flow. We saw between the 2 times that we observed in the CNDA that the rooms also got smaller. We noticed that there were some consequences of this. So you could hear a little bit of what was going on, not in great detail, but through the walls. You could hear when things got heated, for example. So that was the first kind of consequence of, we argue it's the first consequence of the speeding up of the hearings, was actually spatial. So there's a kind of spatio-temporality to law, and I know that there's a really nice, rich literature emerging in socio-legal studies that looks at that. Another consequence of the speeding up that we noticed was a reduction in some of the very important rituals that are usually or often undertaken during hearings. These rituals might be around orientation, they might be about symbolism to do with the law and its authority, but they also crucially are often around respect. So it's making sure that people are introduced, making sure that names are correctly pronounced, and wrapping things up carefully. I said that I'd come back to the figure of the rapporteur. The rapporteur introduces the main facts of the hearing in themselves. They can be seen as a kind of speeding up technology because they are supposed to summarise the hearing and take the burden off the judge for doing that. And they introduce the hearing at the start of the hearings, usually for the benefit of the appellant mostly, rather than the others in the room who've recently seen the paperwork. But what we noticed in the CNDA was just how quickly they spoke. It really was so rapid that it was difficult to distinguish the different words from each other. And it was often in a mumbled, low-pitched voice. Often the judge or the panel of judges would be discussing or doing something else at the same time. So it was almost as if the rapporteur didn't want to disturb the rest of the room by going through the summary of the case beforehand. And we also noticed that the judges often were keen for the summary provided by the rapporteur to not be fully translated, to not be fully interpreted by the interpreter. I'll just give you an example of that. On several occasions, judges appeared visibly annoyed when interpreters seemed to be taking too long relaying the report. For example, by staring hard at the interpreter, raising their eyebrows, looking around the room and at the clock, or making facial expressions and gestures to one another that they indicated they wanted to get on with the hearing. In one hearing, during the interpretation of the report, the President and the Rapporteur exchanged confused, concerned glances. The President said in a hushed but annoyed voice, "She shouldn't be interpreting all of this." The Rapporteur whispered back, "Well, I did specify what should be translated." When the interpreter paused, the President asked, "Have you quite finished, Madame?" She confirmed, "Yes, that's all from me," but then the President reprimanded her. "You need to limit your translation. Don't go over everything. Just the material analysis, like the Rapporteur told you." Along with the significant difference in average time between the rapporteur's reading and the interpretation. So we noticed that the rapporteur's reading could be a good few minutes and the interpretation sometimes less than a minute. It seemed as though a lot of the report was literally lost in translation as a result of this speeding up. And just another note on respect that I mentioned before. At the end of hearings, sometimes quite painful to watch the appellant saying quite emotionally, "Look, I came to France, I'm pleading for my life, please help me." I'll give an example. The appellant pleads and speaks directly to the judge. She is very upset, crying a lot, wiping her eyes and gasping for breath. "I never would have imagined myself in France, and I find myself here due to persecution. 3 years later, I still have no idea what's happening and what will happen to me. I have no contact or news from my loved ones," and she continues to cry, the notes say. The response, and this was quite typical from judges, was to just either nod and say nothing, or say merci, or say next, and that was it. And the juxtaposition between the intense emotionality from the appellant at the end of their hearings that could often happen, and then the moving on, that kind of, it felt sometimes the violent imperative to move on, was really striking to us. And I think, you could argue that the judge needed to remain dispassionate or detached. That's a fair enough argument, but when we were observing that in the hearings, it was really quite striking to us, that juxtaposition between the two ways of approaching timing and approaching the issue. The final of the 4 parts to the discussion, I'm going to just skip that slide, is about presence and absence in the hearings. What I'd like to do here is draw attention to how interesting we found it to look not just at what was present in the hearings and what was happening, but also what was missing. Because we saw so many hearings, it was possible for us to work out what was missing from hearings that we watched. And I guess one of the things that the law sometimes claims to do in its official discourse is to claim completeness, universality. You know, the law is everywhere. And so as a kind of critical response to that, we were interested in what the law doesn't include and what these hearings didn't include as well. I think statistically, there'd always be a tick in a box to say that a hearing had happened. But by looking at absence within the hearings, we're able to critically look at that type of approach to law, which is a kind of box ticky approach to law, and say, well, what was the texture? What was the quality of that hearing? And there were various absences that we can draw attention to. For example, in the UK, around about 10% of the total time of the hearing was spent discussing absent documents that had been spoiled, lost, mistranslated, misunderstood. This was before the turn to digital documentation, and we kept a time survey of the discussion topics within hearings, and we worked out it was about 10% of total hearing time was given over to lost or missing documentation. And the point is that the documentation is able to exert an influence in absentia over the hearings. So there's a kind of material agency even in absentia over the hearings. But let's talk about the missing participants as well. Appellants, legal representatives were sometimes missing from the hearings, and that told us volumes about the appellant and the appellant's case. In fact, it sometimes revealed too much. So in some countries, there's a merits test, a test of likelihood, that government-funded legal representatives will ask appellants' cases to undergo before they decide to represent them. If appellants turn up in court without a legal representative, it can be a symbol to the judge that somebody has judged their case to be unwinnable beforehand, and appellants were very sensitive to this. The most painful type of legal representative absence for the appellant was when the legal representative ducked out at very last minute or in unexpected circumstances. We saw that in various different countries. So we saw appellants that had turned up and they were clearly expecting to be represented. They had a representative, and it had just come as a complete surprise. Maybe they'd been told 24 hours before that the representative had ducked out. Now, it's very complicated, the market for legal representation, and it's not appropriate to be kind of universally critical at all. There are some fantastic judges that work in very difficult circumstances, legal representatives that work in difficult circumstances, and the remuneration often isn't great. But we also saw legal representatives who, for example, stopped at exactly 2 hours through a hearing because they hadn't been paid for more than 2 hours, and they got up, they left the room, and they made it clear that they were only going to come back if they were paid more. So a really kind of intense political economy that operates in this area. Sometimes government legal representatives were also absent. So in the UK, this was fairly uncommon on the basis of our observations, but in France, we never saw a government legal representative. And in Germany, around about the target was about 20% of the time. The BAMF, which is the government department, was about 20% of the time. And judges would get frustrated when the BAMF representatives didn't show up. In general, I think it's fair to say that the German judges were frustrated because they felt that more work was being pushed onto them from the government departments. So that tells a story in itself. And then the judges had to take on the role of questioner and cross-questioner in the hearings. And there was quite a lot of concern amongst the German judges that they were questioning in particular ways, that they were being perceived as not impartial and not independent by the appellant, and how could they assure the appellant that they were independent when they were taking on the role of cross-questioner in the absence of BAMF. We also saw appellants not turning up, and there was a whole kind of moral economy to this, or moral problematic to this. Sometimes judges would really judge, or at least say in the hearings, comments that belied how they had morally judged the appellant and their timeliness and their punctuality negatively as a result of not turning up to the hearings. We also saw lawyers kind of giving up on their cases because perhaps they thought that the judge was going to think that. I couldn't reach my client, so I had nothing more to add, one lawyer surmised, and the hearing was over in 30 seconds. Now, this was in France. Now, in theory, the hearing should be able to go ahead even without the appellant, but when the appellant doesn't show up, sometimes it can have this really important negative effect on the hearing. The final slide, and then I'll conclude. And this is to do with absent presence. What we became interested in a variety of the hearings that we looked at was how the participants could be bodily present, they could be present corporally, but nevertheless simultaneously absent in other registers, including, probably most importantly, mental registers. Here we're following Margaret Davis's work on headscapes. We find that really interesting, and also drawing on the geographical concept of absent presence. So geographers and sociologists have argued, actually for quite some time in the mobilities paradigm, that absence and presence are not necessarily antonyms. You can be absent and present through different registers at exactly the same time. They're keen to get beyond that binary of absence and presence. And that was certainly the case with some of the appellants that we saw. They told us that they'd been present in their hearings, but that the hearing had been a surreal experience. Some of them weren't sure that they'd really been there. Some of them talked about how hungry they were. They turned up hours and hours before their hearing, so worried that they were going to be late. And then they didn't take sufficient food with them, and they were hungry during their hearings and lightheaded. Some were on medication. Some described themselves as mentally incomplete during the hearings. I'll just share a quick extract with you. Was I there? One of our interviewees mused. I wasn't myself. I was sitting there and not taking it in. I didn't understand anything. I hated the whole thing. Mentally, I wasn't there. Appellants talked about stress. So ahead of the hearings, interviewees commonly reported sleep loss. When you go to the court, you prepare yourself. Maybe you sleep, you panic, you stress. Maybe you don't sleep, or will not sleep. So we'll be in a mood which is not good. Sometimes this was associated with debilitating levels of panic in the hearings. You're scared. You're like scared of saying anything, one appellant explained. They ask you a question and you get a panic attack. When you get a panic, you can't say what you would like to say. Some felt that their ability to receive verbally transmitted information was consequently impaired. I was stressed. I wasn't even listening properly. My head was buzzing. Some people talked about forgetfulness and terrifying levels of forgetfulness, actually. Before I go to that court, I had so many things to say, but when I was there, it was all completely out of my brain. I didn't remember anything to say because of the situation. It was really stressful and nervous for me. It was a really big issue. I forgot everything. Parents, mothers, usually also talked about distractions from their children. There's a really important issue about childcare for asylum appeal hearings, which we've not really had time to discuss here. I have mentioned it in other publications. Some women have to choose whether or not to take their child in with them or leave them outside. If they take them in, it can impair disclosure, or it can give the child a negative experience because they're watching the mother potentially in tears. If they leave them outside, then the mother could be stressing and worried about what's happening to the children. Of course, the rules say you shouldn't take your children to the hearing centre, find someone else to look after them. But with weakened social networks, some women don't have that option. And it's something that we as ASYFAIR have tried to raise awareness of in various different contexts in the past. But here's a quote from one woman who decided to leave her young daughter outside the hearing. I was there with my daughter, but one of the security guards had to watch her all the time. I was really stressed as well because I was thinking about her. When she cries, she wants to come into the room, but they kept telling her to get out. It was difficult. Okay, we faced various methodological challenges, which I don't have time to discuss now, but I'd be really happy to talk to you about in terms of access, in terms of whether or not we affected the hearing, in terms of who to notify that we were going into the hearings, in terms of data collection, ethics, so various things that we can talk about there. We've also attempted to have an impact through our work. These are just some of the, so a couple of publications for non-academic audiences, and then a film, the below picture with the cartoon figures is a film for asylum applicants to tell them what to expect in their hearings. So I'll just move on to some conclusions. We're really interested with ASYFAIR to apply a socio-legal perspective to refugee law. It's not the first time it's been done, but it's been done to great effect in the past, and we'd like to carry on that tradition. One might think about law as solid and dependable, and indeed, the law gives that that image of itself. It projects that image of itself. But our research question is, what makes law, refugee law, fragile? What makes asylum appeals in particular fragile? Meaning prone to damage and ineffective. And some of the responses, some of the answers that we've come up with in our research include the fragility of subjects. I've not really spoken much about that, but elsewhere we've argued that the law relies on its subjects. It relies on a certain degree of cooperation, participation, and engagement. And so the law is actually as fragile as its subjects. We've also talked about the inseparability of the legal process from its Western context via kind of the assumptions and lenses through which the questions are imparted and through which some of the key actors engage in the hearings. We emphasise group work and the group nature of the production of asylum appeals and appeal processes. And so including the clerks, including the security staff, including the court writers, which we didn't get to talk about, and how susceptible the law is to each one of those actors within the group. That's something that comes through from our ethnographic observations. We talked about how deeply politicised the asylum appeals are. So on the one hand, they're formally independent from the state, but as a result of time shortages, as a result of upstream decisions, sometimes shortages of expertise upstream. So when I'm talking about upstream, I mean the initial state decision can impact upon and put pressure on the judicial appeal process. And I think it's fair to say that there's an over-reliance on the appeal process in Europe in comparison to the first instance decision. It's something that was very frustrating for the judges, and it's something that we saw in that quantitative pressure and the speeding up that I was talking about. We saw the consequences of it in our research. And then finally, I think it's interesting to look at how fragile and susceptible legal processes are, legal appeals are to absences. I think there's more work to be done that we didn't manage to do on paper-based appeals, the absence of an in-person hearing and the pros and cons of that. But within the hearings themselves, the absence of various different parties can have in itself, in absentia, a very important effect on the hearings. And I'd argue, what we argue in our work is that a full legal materiality involves an attention both to absence and to presence. So drawing on work in socio-technical studies, John Law's work in particular, a full understanding of materiality, which is something that I know legal scholars have turned to in recent years, requires that we look at both absence and presence for that full picture. A couple of slides to finish. So maybe you can go back through this list of publications. Quite a few of these are open access. If you can't get hold of them, I'd be really happy to share them with you. And we have a conference in later on this year. It's going to be online, 20th of June to the 3rd of July. I'd be really happy to welcome you to that conference and continue our conversations there. Okay, let's go to the Q&A now.